Be ready? Start. It has been suggested that the effect of the words and not more is to exclude the operation of those provisions of the Limitation Act referred to in class bracket A of section 29 bracket 2 stop. The inclusion of these words is no doubt indicative of the intention of the court that the presentation must be made within the time allowed, save only as the rule then provides. If the judge thinks fit to grant further time, stop. The provisions of the Limitation Act mentioned in class bracket A of section 29 bracket 2 have, however, effect insofar as and to the extent to which they are not expressly excluded by the special or local law, and in my judgment the use of the phrase expressly excludes negatives the exclusion of these provisions by implication. Stop. I do not therefore think that the words and not more have any effect other than that of emphasis stanza. I am therefore of the opinion that the provisions of section 12 bracket 2 apply in computing the period of limitation for an appeal under the letters patent. Stop. This subsection, so far as is relevant, provides that in computing the period of limitation prescribed for an appeal, the day on which the judgment complained of was pronounced and the time requisite for obtaining a copy of the decree appealed from shall be excluded, and in view of the decision of the Privy Council, it is not in dispute that if this subsection applies, the appellant was entitled to exclude the time requisite for obtaining a copy of the decree appealed from, and that this appeal was preferred within time. Stanza. In view of the opinion I have formed on the first submission of learned counsel for the appellant, it is unnecessary for me to consider the second argument which he has advanced, and on that argument I express no opinion. Stop. In my judgment, the appellant is entitled to exclude the time requisite for obtaining a copy of the decree appealed from, and I would answer the reference accordingly. Stanza. The question referred to this bench is as to whether in computing the period of limitation fixed by the rules of this court for preferring a letters patent appeal, the time requisite for obtaining copies of the judgment and the decree should be excluded. Stop. The arguments advanced by Mr. Kirti, learned counsel for the appellant, are that the rules framed by this court under the letters patent are special or local law. Full stop. Over.